crud that's going around. And so he's not going to be able to be here. So I'm sitting in for him. First bill for consideration will be Senate File 175, unemployment insurance coverage, period and reporting. Senator Kolb is behind the pillar.
Hi, I think Mr. Co-Chair. Mr. Co-Chair, I have some pre-written out amendments that I give them to the staff.
Give him, yeah, to hand out. Yes, do that. And I will mention that Senator Crum will be here directly, but he's defending another bill, a bill on another committee, so he will be here later. Proceed.
Yeah, thank you, Mr. Chairman. I'd like to take into consideration the amendment. I think it's important, and when we talk about the whole bill, and I'll just briefly talk about it. Yeah, the amendment strikes page 1, line 10, delete 27-3-116, subsection G, Romanet 2. It takes it out of the bill, and there's a reason for that. Just briefly, there was an issue with federal compliance because of that ratio change, and then after reviewing what it really did, it doesn't really do anything to the bill because that provision doesn't get enacted very often, I think twice. And it also provides actually more of a reassurance that if a situation happened that would trigger that event, there would be in fact a safety net for the unemployment insurance system to extend benefits. So that's why the reason for the amendment. And with the amendment, Mr. Chairman, it was found out that January 4th of 26 would be an appropriate date according to the department because of an issue about how it fell in the week. So the effective date change would be added to January 4th of 2026, Mr. Chairman. And I'd like to explain the bill.
Okay, go ahead. We'll deal with the amendment in due course of time.
As your prerogative would dictate, Mr. Chair. Oh, can't hear me? Well, that's a first. So this bill, this good little bill here, this is the second time around for this guy. He made it through in 2022 out of the Senate, engrossed. And this, what you're seeing in front of you is the engrossed version minus the amendment. Now, what does this bill do? Factually speaking, it changes the maximum time of an unemployment benefit from 26 weeks to 20 weeks. In essence, a little bit more than 20% decrease of maximum benefits. Well, why do we need this? It lowers the cost for employers for doing business in the state of Wyoming. That's really the bottom line here. We're trying to decrease the cost. Now, common thought is the maximum amount of time that people would take benefits, and the average UI benefits 13 weeks currently. Under 11% max out their UI benefits, so just over 89% do not use the maximum of unemployment benefits. And once again, it decreases the cost for businesses. Now, another part of this bill is it renames the Unemployment Commission to Reemployment Insurance Commission. And that's really a thought, an expectation that we would change the expectation to reemployment instead of unemployment. It just sets a different, I think, goal, I guess more exact goal. And can't read my notes here. So that kind of just explains it in a broad sense. Like I said, this bill's been gone through the system once. I think there's a broad-eyed thought that being that most people do not take these benefits for the maximum amount of time, this would be a good step into lowering the amount of time that you could take the maximum benefits. And that's really what this bill is attempting to do. And with that, I'll stand for any questions, Mr. Chairman.
Okay, questions? Questions? Seeing none, thank you very much. We'll throw it open to public testimony. Does any of the relevant agencies want to lead off? Yes, ma'am. Have a seat, tell us who you are, and then proceed.
I am Liz Gagan, and I am the Director of the Department of Workforce Services. And with me, I have Holly McCaney-Simone, and she is the Administrator of our workforce programs. And online, we have Chris Funk, who is the Administrator for the UI Division. I intend to speak, but Ms. McCaney-Simone and Ms. Funk may need to help me if you have detailed questions.
Okay, and you've got to speak up. The acoustics in this
Okay.
room are not good.
Okay.
And
Is that better?
we have to be able to hear you.
Okay.
Okay.
Yeah, so just give me a sign if I start to dwindle off. I just wanted to give you a little information about where unemployment rates are right now. We recently released the December unemployment rate. It was 3.5, and that was up from 3.3 in November. These are seasonally adjusted, and that's the normal seasonal pattern for Wyoming. Generally, unemployment goes down in between the first and the second quarters. It goes down then even more in the third quarter, and then in the fourth quarter, it tends to rise. However, unemployment was 2.9 about a year ago. So we know that unemployment is kind of on the rise, and this is consistent nationally. The US rate is currently 4.1, and Wyoming has the 20th lowest unemployment rate. I did want to just give a history of kind of where the 26 weeks came from in the first place. Wyoming adopted the 26 maximum in 1957. Prior to that, there was no maximum to the amount of weeks that someone on UI could claim. We don't know exactly where it came from, but we know that the Department of Labor was recommending 26 weeks for states to do. And following World War II, all states were at 26 weeks. And then, the Great Recession happened. And so starting in 2010, some states did start to reduce the number of weeks available for UI claimants. The belief being that their trust funds were, kind of in trouble, and this was a way to get their trust funds more solvent. 33 states needed to borrow money from the feds during the Great Recession to pay their UI benefits. Wyoming did not. And Wyoming had been kind of operating on a UI system and formula that had been in place since the 1980s. There are currently, I believe, about 14 states who have weeks less than 26. And our neighboring states, Colorado, North Dakota, South Dakota, Utah, and Nebraska, offer up to 26 weeks. Idaho offers up to 20, but 26 weeks if the unemployment rate is 5% or higher. Arizona offers 26 weeks if UI is greater than 5%, and if not, 24 weeks. And Montana is at 24 weeks. I do agree with the bringer's statement that it will reduce costs if there are, less people on UI. That will reduce costs to employers. I am, though, I don't know that it really pushes people back into reemployment any sooner. I looked at the December 2024 UI rates in the United States. The 10 states with the lowest UI rate all have 26 weeks. In between 10 and 20, 6 of those states have some level of reduced weeks. And then the bottom 30, there's a handful of states in there who have less than 26 weeks. So I'm unaware of a correlation really either way, that it either gets people, back to finding a job and into a good job or not. I do want to say that currently the duration of a UI claim in Wyoming is 10.3 weeks. Last year it was 10.4. The year before that, it was 14.7. And I will note, when it was 14.7, we did have a higher UI rate. Our UI rate has been really pretty historically low over the past 2 years, but it is rising, as I said. I have provided you, if you care, the Wyoming Workforce Annual Report, and there is a fairly long article in here just about UI. And there is a table, it's on page 33, that just shows the average weeks claimed by industry, if you're interested. What we have seen, we did look at this bill 2 years ago, and looking at it again today, we wanted to kind of get an idea of who may be the most impacted by cutting the weeks. And so I did provide a listing of all of the UI claimants who have been on UI for at least 20 weeks, and then had it broken out by occupation. And so if we look at kind of the top 4 occupations, we have operating engineers, general and operations managers, heavy and trailer truck drivers, and construction laborers. So they're generally fairly high wages, fairly high skilled jobs. And we saw the same thing when we looked at this bill before. There were, again, high wage, high skilled jobs, but then it was petroleum engineers, interviewers, construction and building inspectors, and rotary drill operators who would have been the most affected by a decrease in weeks. So, it seems that generally high-skilled, high-wage people have a harder time finding a job after being laid off. I also want to talk about wage replacement rates. On page 37 of the book that I provided, it shows average wage replacement by industry. So we can see that if you are in the construction industry, your wage will be replaced generally to about 39% of what you would have been making if you were working. Mining, a miner's wage is about 25%. And then the management of companies and enterprises is about 11%.
When you say 11%, 11% of what?
Of their regular wage. So if I were in the management of a company and enterprise, my wage on UI is at about 11% of my wage when I was employed. Just to show that, people don't make very much money when they are on unemployment insurance. We also, pursuant to Wyoming Statute 27-3-307, that allows for approved training programs and for people who are in training programs to be able to draw UI if it is approved. And so this could affect people like that. In 2024, we had 68 claimants who were in approved training program, and 21 of them exhausted their benefits. And that's a pretty low number. In 2019, we had 222 people in approved training programs receiving UI benefits. So that could be a group of people that may be affected if weeks are reduced. And then, historically, Wyoming has had boom and bust. We know that there have been times in the not too recent past, when a coal mine has been shut down without any notice, and those high-skilled, high-wage miners do have a hard time finding employment after those types of events. In addition, UI taxes, of course, pay benefits, and that's the vast majority of what they do, but they also help to pay for some of the employment programs that we have through what's called the Employment Support Fund, which is a statute that flows some money into the Department of Workforce Services to help fully fund really the UI program in and of itself, as well as other reemployment parts of our agency. I will say it's very difficult to really estimate how much a change in weeks may affect that money that we use to run the program and other reemployment programs. I will tell you, though, that we report on our use of that fund every year. And so as members of this committee, going forward, you will start to see a report so you can see where that money is going. And I want to talk briefly about a new program, it's been in place since June of 2023, and it is called Reemployment Services and Eligibility Assessment Program. And this was funded through the Department of Labor. We call it RECIA, and it really targets UI claimants and focuses on rapid engagement and reemployment with those folks. So what we're doing is every week we have an algorithm, and it picks the 40 UI claimants that they believe will be on UI for the longest duration. And we start this rapid engagement with those folks. So a list goes out to all of our workforce centers on Friday. And then by Tuesday, we have made an initial appointment with those individuals. If they don't meet that appointment, then they're not eligible for UI for that week. And at those appointments, we do eligibility and work search review. We're not always certain that people are very good at looking for work. So we want to make sure that they are and help them with that. We enroll them into our Wagner Pizer services, which is basically our job search board. We provide customized labor market information, and we're also letting them know all of the services that DWS can provide. So we are very engaged with trying to get people back to work. Once we, in the future, we would like all claimants to be a part of this program. We just don't have the bandwidth to do it right now. And that is all the information that I have, but I'm happy to answer any questions that you may have.
Questions? Senator Steinmetz?
Thank you, Mr. Chairman, and thank you for your report. Just one statement, being an employer myself, I find this, I think this is a good bill because it starts reducing the impacts on us, but also I feel like the system is becoming more weighted toward just the employee without as much consideration of the employer, which is all the backbone of what we're trying to do here, keep people working and having a paycheck. With that said, you mentioned that we were one of the states that didn't borrow to pay for unemployment insurance, and I remember a huge infusion of ARPA dollars into that when we got the COVID money. And then also you said 20 weeks is a long time. So could we reduce it? I mean, maybe we could reduce it even further, because I'm not sure the employment support fund and training and all of that. I would like to know how many employers really want to keep paying for that. because our bottom line is hurting. Small businesses and industries are struggling to stay afloat right now. And so it's high time we look at reducing some of these services. So with that, I would appreciate you addressing if people aren't using their benefits for 20, to exceed 20 times the weekly benefit, or if it, can we reduce that number even more?
I'm sorry, Chairman Scott, Senator Steinmetz. I think reducing that anymore would be a larger burden on people who are trying to find work. I don't know that people want to not, go back to work after they are unemployed. But it does take a while for people to find a suitable job.
Follow up, Mr. Chairman?
Go ahead.
Well, I've found a lot of employees shopping. So they'll come for interviews to meet the requirements, but they're not really that interested in the job. So there's another side to this, is what I'm trying to tell you. And we're the ones paying for this, and so it would be important for you to start working on that side a little more too, not just for the employee, because it's nearly impossible to fire someone these days. And I've had employees even claim unemployment insurance on me for times they weren't even working, and then I had to do all the paperwork to show everyone that it wasn't even a qualified time. So I find it highly weighted for the employee, and the employers who are providing the jobs are getting left in the dust.
And I'm sorry.
Go ahead.
I would certainly encourage any employer who feels like an employee is engaged in some type of UI fraud. And what you mentioned, found people kind of shopping, coming to interviews and not really being interested in the job. I think what you're suggesting is that the claimant is trying to show that they're actively seeking work because they have to keep their UI benefits.
That's right.
I mean, that would be an indication of fraud, that if you would report to the Department of Workforce Services, we will look into, and the claimant may not be eligible. But if there are, any other, issues, I encourage employers to reach out, and we're always happy to help.
Thank you.
Okay. Senator Hutchins?
Thank you, Mr. Chairman. Just a quick one for Mrs. Coggan. The Employee Support Fund statute, do you have that?
I do.
And thank you for the information you provided.
Mr. Chairman, Senator Hutchings, it is 27-3-11.
Thank you.
Let me ask one question then. Current status of our fund, do we have any potential solvency problems, or are we in good shape right now?
I'm sorry, Mr. Chairman. The trust fund balance is $500 million, and we don't have any solvency issues.
What do we spend in the average week or month or whatever period you use?
Mr.
Benefits.
Chairman, I don't know.
Mr. Chairman, Holly Simone, Workforce Programs Administrator. The most recent data that we have is the total benefits we have paid. Let's see, this was for 2023 was $45.1 million.
So we have better than 10 years? Or is that an annual figure you gave me?
Yes, that is an annual.
So we have better than 10 years in our trust fund at that rate?
At that rate. And 2023, we had our lowest number of UI claimants since 1997.
Yeah, okay. Thank you. Anything else? Senator Hutchins?
Thank you, sir. I don't know much, thank God, about being on unemployment, but I was wondering if an employee, or like the ones you mentioned, the high-paying ones on page 33, jobs, they've lost their job, they're looking. What if they say, hey, I work at Walmart and Target, a few jobs in between, until I can get something that will satisfy my skills and abilities. Does that keep them on unemployment, or are they then employed and they don't receive anything if they take part-time work?
Mr. Chairman, Senator Hutchings, generally, if you are receiving a wage, you won't receive UI. It is possible if, maybe you worked for a day or you worked for a couple of hours, that it wouldn't be enough to, you would still receive some UI, you wouldn't receive your full benefit. But yeah, if you take a lower paying job in the interim, you won't be on unemployment at that time.
Okay. Okay. Thank you very much. Who wants to be next? I will ask people to be brief and blunt and to the point, because we are under time pressure and we've got a complicated bill that's second up. So, Mr. Twinney. And anybody else that wants to testify, come up and line up and take a chair.
Well, Mr. Chairman, Bill Winnie from Sublette County. Had not intended to get up, but some of the questions and by Senator Steinmetz sparked me to that. My wife is an educator that was let go out in a school district in a disgustingly unprofessional manner. And one of the threats they used against her, sometimes subtle, sometimes not so subtle, was if you ever want to teach again. Well, she was old enough where that was an empty thing, but that's what educators sometimes face. Subject to questions, thank you.
Okay. Thank you. Next, introduce yourself, proceed.
Mr. Chairman, thank you, members of the committee. Thank you for giving me just a minute. I will be brief, Mr. Chairman. I thought the director did a very nice job on her presentation and had some really helpful information. By the way, I'm representing FGA Action today. I forgot to mention.
And say who you are.
Jeff Doherty. Forgot to
Doherty.
mention that too. Yeah. Okay. So with that said, I would tell you, we started talking with Senator Kolb a couple of years ago, and what we've sought to do was an indexing bill that's been implemented in other states. But we decided it was a little too complicated, and the easiest path forward was just to go a flat rate reduction. Mr. Chairman, work is a blessing, and our goal here is to get people back to work faster. And we think this bill helps. It's not a panacea by any means, but work gives people a sense of purpose. And the longer you have, the longer you can take. I've got some quick pieces of data, Mr. Chairman, and I'll be quiet after that. But according to our research, about 16,000 or 17,600 people applied for benefits in Wyoming last year. Most of them, as the director indicated, were on there. We show about 13 weeks, but pretty close to what the director said. Only a handful of those folks maxed out. Only about 1,800 maxed out on that program. But I would tell you, Mr. Chairman, that states like Kansas, Louisiana, Texas, or Tennessee, Florida, Idaho, Arizona, they currently index. And in cases where you index, which we're not doing here today, you can realize 25 to 50% savings to those employers making contributions. And I wasn't able to pull data together for the flat rate, but I will get that if this bill passes and moves forward. But I will tell you that employers are struggling. They can't find people to work. And there is no reason a construction worker even needs the amount of time we're given. 13 weeks is the average. We felt like 20 was generous and reasonable to move forward with. In the interest of time, Mr. Chairman, I'm going to end my comments there unless you have questions.
Questions? Questions?
Thank you.
Okay, thank you very much. Who's next? Yes, sir.
Jerry Payne, Senator. Thank you, Chairman. I'm coming from the electrical industry, linemen, electricians. and I wanted to speak on behalf of this. None of our people are looking to be laid off and on unemployment. They're looking for employment. They want to stay working, but we have ebb and flow. We're a highly energy dependent state, oil and gas, coal, all that. Our people, you know, I'm 35 years into this. I've seen it, I've touched it, not a lot of times. I've always been able to stay. But what we're seeing is if we don't help people stay in the state, they leave. And when they leave, they don't come back. I've seen generations of workers that we put time, effort in training these people to do these jobs. When oil and gas pulls back, they leave the state, they don't come back. If we can bridge the gap with this kind of a benefit to keep them in the state of Wyoming, that helps the worker issues that we're hearing from the contractors and employers. You know, I've seen it time and time again, and it's an issue. And I think nobody wants to stay on unemployment. But if we can bridge that gap to get them to the next employment opportunities, I can tell you a big line job here just the last couple of years, every winter, we went from 170 guys down to 6. BLM, big game restrictions, and winter. And then we're looking for 170 people go back to work in April. We've bridged the gap with that. You know, it's not perfect, but we got those jobs done, and that's, you know, an industry that needs to keep those people going. I'll end my comment. Thank you.
Okay, thank you very much. Yes, ma'am, you're next.
Thank you, Mr. Chairman, members of the committee. I'm Marcy Kindred, representing hardworking families across our state as the Executive Director of the Wyoming State American Federation of Labor and Congress of Industrial Organizations. I stand before you today in opposition of this bill because Senate File 175 threatens a linchpin of Wyoming's workforce, our skilled workers who weather the ups and downs of our resource-based and often seasonal economy while choosing to keep their families here in Wyoming. Unemployment insurance is not a handout. It's a lifeline that our workers have earned. When a roughneck gets laid off during a downturn or when a tourism worker faces seasonal layoffs, this insurance helps bridge the gap until they can get back to work. Our people don't want a free ride. They want to work, and they want to work here in Wyoming. The reality is our current benefit amounts are barely enough to cover basic needs as is. We're not talking about luxury. We're talking about keeping food on the table and a roof overhead while our people search for suitable work. Those 26 weeks are not often used as a solid block of time. They're a lifeline stretched across a full year term from the initial claim. 3 weeks here during weather delays, 2 weeks there while a project pauses for BLM review. It's how our workers survive the stop and start nature of Wyoming work. The Department of Workforce Services mentioned workers in training programs being able to utilize UI while in these programs. And there was a question about if employers want to pay this. And I'm sure I'm obviously not speaking for all employers, but we all know that Wyoming has workforce issues. We want to employ skilled workers from Wyoming, but they can often be in short supply, and then employers are forced to bring in temporary employees. It would seem to me that this opportunity helps us train our Wyoming workforce, folks from here that want to stay here, build their lives here. Seems like a good opportunity. I wanted to speak on the proposed rebranding of this program. It may seem minor, but I think it reveals something deeper. It questions the very character of our Wyoming workers. Our people don't need a reminder to seek work. They're already doing everything in their power to get back to work. We're proud of our Wyoming values, independence, resilience, looking out for our neighbors, and this bill undermines all of that. The question before us cuts to the heart of who we are. Do we want to keep our skilled workforce in Wyoming? I'm afraid if we pass this bill, we're telling our workers we don't trust them, we don't value them, and they should seek opportunity elsewhere. And friends, once Wyoming workers leave, they rarely come back. I urge you to vote no on Senate File 175 and stand with Wyoming workers. Thank you for your time, and I'll stand for any questions.
Questions? Thank you very much. Anybody else? Oh, excuse me, Senator Hutchins.
Thank you, sir. I'm sorry about the late question. Marcy, what do you think about what Senator Steinmetz mentioned about people who come in and fake looking for a job? And from what I'm hearing, it's happening enough to really be a problem. What do you think about that?
I think that with the report from Chairman, Senator Hutchings. I think with the report from our Workforce Service Department, they did address some of these issues. There are checks, that's fraud. We have ways to challenge those cases, and those should be utilized if people are taking advantage. And sure, I'm not here to say it never happens. However, the vast majority of folks who do utilize these benefits are doing so they can stay in Wyoming where they want to stay. We don't have the most competitive salaries. We can't offer a whole lot to get folks, our skilled workforce, to stay here. If we're gonna cut these, that's just one of the things. They're not going to be able to try and make it work to stay here in between those seasonal layoffs or pauses in work, and they're going to be forced to go elsewhere. That's the vast majority of the folks utilizing UI.
Okay. Seeing no further questions, thank you very much. Anybody else want to testify? Anybody else? Anybody else? Yes, sir.
Thank you, Mr. Chairman. My name is Kevin Reddy. I'm the president of the Federated Firefighters of Wyoming, and I represent the career firefighters across the state. We rise in opposition to Senate File 175. We have a lot of concerns in that our members are part of those highly skilled trades that were mentioned by the department. And to further complicate things, while firefighter layoffs are extremely rare, reemployment in the fire service is governed by civil service rules. And so getting another job in a Wyoming Fire Department, a member might have to wait up to a year or even 2 years to get back on a list, or wait for seasonal employment in wildland applications in the fire service. And we could see a lot of our members, should layoffs happen, going to other states where wages and benefits are much more competitive than here in Wyoming. So we stand in opposition to the bill. And with that, Mr. Chairman, I'd stand for any questions.
Okay, questions? Thank you very much. Anybody else? Anybody else? Anybody else? Okay, public testimony is closed.
Mr.
Right.
Vice Chairman, we do have online testimony as well.
We do have one more?
We have 3 people who would like to testify online.
Okay, put them on quickly. We need to move along here. Okay. Yes, sir, can you hear us?
Yes, sir.
Go ahead.
All right, thank you, Senator Scott. I represent the Wyoming Operating Engineers.
Okay.
I just wanted to oppose this bill, and I'll try to keep it as brief as I can. You know, Wyoming has 2 seasons, construction season and winter. I don't see how it would help our already struggling Wyoming workers to cut these benefits further. We want to keep our workers in our state. A lot of our new apprentices and the kids we hire out of like the Job Corps, they already don't get any assistance from unemployment if they come straight out of high school or out of a program like that because they haven't worked long enough before that. So we teach them to save their money during the work season and not really to depend on unemployment, because the layoffs can be, like it's already been said, it can be October, November, December, January, February, and March, potentially. Depends on contractor start dates, weather. But I think the main point is that, Wyoming workers don't want to be on unemployment. Our guys don't want to be on unemployment. It's not because they're lazy or unwilling to go to work. It's solely due to a lack of work. During a good portion of the winter, and large out-of-state workforces controlling a lot of the construction market in Wyoming and do not hire local workers. So these guys are forced to go to states like Colorado, Montana, Utah, away from their family, because it's not always an option to just go get a job at Walmart. In these times, of being laid off in Wyoming, I don't know if any of the council members have ever experienced being on unemployment, but if you did, you would know how stressful and trying it can be with your home life and trying to pay, car payments and house payments and everything else. And I also, I kind of wanted to make a comment about Ms. Steinmetz's remarks earlier, and I think we need to remember that we represent the Wyoming workers. We're not here to represent ourselves. We're here to represent the state of Wyoming and the people of Wyoming. And I'll end my.
Okay, for the record, could you tell us exactly who you are?
Oh, yes, sir. My name's Philip Cornella.
Okay, questions? Thank you very much, sir. Who's next?
Thanks, sir.
I believe we're done now, Vice Chair.
We're done, okay. With that, we'll close public testimony. Committee, what's your pleasure?
Move the bill.
Okay, bill's been moved. There was a proposed amendment,
I'd move the amendment.
been moved. Any further discussion on the amendment? Further discussion? Okay, all those in favor of the amendment, say aye.
Aye.
Opposed? That carried. Back on the bill. Any comment in the bill?
Thank you, Mr. Chairman. The number one thing I heard over and over was that people aren't maxing out on the benefits, so they're not hitting that 26-week, which I thought was really nice. And I like the testimony from the last gentleman, Mr. Cornella, in that they're teaching these young people that are on seasonal work, hey, start saving your money because you don't want to depend on unemployment. So I think that's a good step forward. And that's about it. More encouraging than not for the bill.
Okay.
Thank you, Mr. Chairman. And just to the last speaker's comment, I'm not here to represent myself. I'm here to represent small businesses and employees. And I see things, I get complaints about this from my district all the time, not just from myself, but others. So I think we need to make sure we have the right balance, and this bill starts to move us in the right direction. Thank you, Mr. Chairman.
Okay. Okay, I will explain. I'm going to be a no vote on the bill because I think there is a pretty good balance and we aren't seeing people max out much. And it does sound like it's a problem in the high-skilled areas that are particularly seasonal workers. And I think removing the time would cause a problem in that area. Anything further? And we are running with the reduced committee, so if we don't have a majority this time, we may consult the other members. So call the roll, please.
This is a roll call vote for Senate File 175 as amended. Senator Crum?
He's excused.
Senator Hutchings? Aye. Senator Scott?
No.
Senator Steinmetz?
Aye.
And Chairman Barlow has left an absentee vote of no. Mr.
so
Vice
we-
Chairman, that is 2 aye, 2 no, and 1 excuse.
What we're going to do is hold this open and see if Senator Crum chooses to vote, and that we'll deal with that. So, sorry, audience, we didn't come to a firm conclusion because it winds up with the 2 no votes. There's a tie. We'll consult Senator Crum and deal with it, so it may or may not go upstairs. So with that, we'll go on to the next bill, Senate File 125. You can go up there, or you can talk from here, depending on what your preference is.
That's the amendment. I had given you the track-in version, but.
Yeah, God knows where it is. Senator Steinmetz, go ahead.
Thank you, Mr. Chairman. Sherry Steinmetz, Senate District 3. And today I bring you defining healthcare and protecting the people's welfare. I have also passed out to you an amendment, and I gave everyone a tracked-in version a couple of days ago. And so I'm going to read the bill with the amendment inserted because this bill has been through a lot of drafting revisions. And the first one we had done, we cited some acts that were passed in House Bill 152, which was the Life is a Human Right Act, but because those have been enjoined, they don't show up in our statute books, and so I went ahead and just took the definitions out, and so that is what the amendment does. So this is also housed in a different section of law. It is under our common law and statutes and rules of construction. From what I understand from the originator of this idea, that's kind of an overarching law, section of law for state law. And so with that, Mr. Chairman, subsection A would read, for purposes of definition, interpretation, and construction under the Wyoming Constitution and all statutes of this state, Romanet I would read, healthcare shall mean acting to promote the curative, improving, healing, restorative, therapeutic, physical health and well-being of a person, including an unborn person, from the moment of conception herein defined as life. Healthcare shall not mean actions that terminate life and are hereby prohibited except provided in this section. And that, oh, whoops, I read the wrong one, I'm sorry. I read the wrong one. I have to start over. That was the previous amendment. So section A is the same, but healthcare shall mean acting to promote the curative, improving, healing, restorative, and therapeutic of physical health and well-being of a person, including an unborn person, from the moment of conception herein defined as life. Healthcare shall not mean actions that terminate life and are hereby prohibited except as provided in this section. Abortion as defined in paragraph II of this section shall be defined as healthcare only if the abortion is medically necessary to save the life of a pregnant woman by performing a pre-viability separation procedure necessary in the physician's reasonable judgment to prevent the death of a pregnant woman, a substantial risk of death for the pregnant woman because of a physical condition or the serious and permanent impairment of a life-sustaining organ of a pregnant woman, provided that no separation procedure shall be deemed necessary under this section unless the physician makes all reasonable medical efforts under the circumstances to preserve both the life of the pregnant woman and the life of the unborn baby in a manner consistent with reasonable medical judgment. And then Romanet II defines abortion. Abortion shall mean an act, procedure, device, or prescription administered to or prescribed for a pregnant woman by any person with knowledge of the pregnancy, including a pregnant woman herself, with the intent of producing a premature expulsion, removal, or termination of a human embryo or fetus, except that in cases of which the viability of the embryo or fetus is threatened by a continuation of the pregnancy, early delivery after viability, by commonly accepted obstetrical practices shall not be construed as an abortion. And then it goes back into the subsection that was 2, that becomes a 3, which then says no act, treatment, or procedure that intentionally causes harm, that's a change, to the heart, respiratory system, central nervous system, brain, skeletal system, joint or muscle appendages, organ function shall be construed as healthcare unless documented and medically necessary, this is an insertion, necessary for the treatment of an illness or injury documented and medically necessitated to save the life of a person, or in cases in which a licensed medical provider has deemed and documented that a person has no chance of meaningful recovery from an injury or illness that recommends terminating life support services. Subsection B, the definition and rules of construction of this subsection of this section shall not apply to the Wyoming Healthcare Decisions Act. And then subsection C, the legislature recognizes the need to protect the health and general welfare of the people of Wyoming in accordance with this purpose. The definition and rules specified in this section are provided to advance the health, welfare, and safety of all the people in Wyoming. Then section 2 is added, which makes it effective immediately. So thank you for your indulgence in reading all of that, but we've had so many renditions of amendments trying to make this a good and reasonable bill that I just needed to read the whole thing for the record. So that is the proposed amendment and the bill all rolled into one, Mr. Chairman.
Let me raise a few things.
Okay.
First, let me ask you, my understanding is that this amendment is absolutely essential to the bill. And I could not make head and tail out of the bill. There was some kind of a drafting mix-up.
Thank you, Mr. Chairman. You are correct.
Okay. First, you've defined abortion here pretty carefully, and it is strictly where there's somebody actually doing something, right? What I've seen in the past is that the medical people often call what us laymen call a miscarriage, call a spontaneous abortion, and don't realize the effect of the legal definition in places like this, and think that you're reaching what we call miscarriages. And am I right in thinking this is very carefully defined, so abortion does require some kind of a voluntary act by somebody that's trying to initiate it and cause it? Is that right?
Mr. Chairman, that is the intention.
Yeah, okay, and I stress that because I've seen confusion on these bills before. I will comment then that the idea that of unborn person, and really where my church stands, is that someone becomes a person at birth, and it is, before then, it is the mother's choice. And I respect the point of view that this bill sets forth, as I think we all ought to respect other differing religious opinions. But frankly, I do not like the tendency to impose one religion's belief on another, and I think that's what's going on here. But that's
Okay, I've said my piece on the amendment.
Mr. Chairman, I know there are others who would like to speak to this bill.
Yeah.
And if you don't have any questions for me, I'd love to give them the opportunity.
Okay.
Because we have not much time.
Yeah, and for the audience, we're due upstairs at 2:30. We're going to honor that and we're doing important work up there. We've got it, we're going to cut the testimony off about 10 minutes after 2, no matter where we are, and bring the bill to a vote. So guard your comments accordingly and no filibustering.
Thank you, Mr. Chairman. I actually had a comment on top of your comment. Yeah, the bill draft, going through it, there are a couple areas where I have some questions as well. But one of the things that I find most fascinating when it comes to bills like this, sir, is that we tend to let our churches and other people tell us how to think and view things. But I like to go to the Creator who created heaven and earth and everything in it to be my judge. And that's just my quick little statement. Thank you, Mr. Chairman.
Okay, with that, who wants to testify on this first? It doesn't particularly involve state agencies, and I don't see them here anyhow, so go ahead. Okay, we'll go with Mr. Winnie first, and then you're second.
Oh, excuse me, Mr. Chairman, I had offered, anyway, I support the bill, Mr. Chairman. Why do we need this bill? We
And
need
Bill,
this
for the
bill.
record, tell us who you are.
I'm sorry, Bill Winnie, Sublette County. So we need this bill. I recall a funny line from Lewis Carroll in one of his books, Humpty Dumpty, where he says, "Words mean exactly what I want them to mean, and nothing more, nothing less." And I've sat here in previous legislative sessions and heard medical personnel come up and say, an abortion is health care. Well, sometimes it is, and I got it on things like ectopic pregnancies, but sometimes it's optional. And one of the things I learned on my way to and in command on Navy ships was sometimes you need to take your glasses and turn them around and look at it from the perspective of that infant. Subject to your questions, thank you.
No questions, thank you. Yes, sir, you're next.
Oops.
Oh, you do have.
Quick one,
I'm
Mr.
sorry,
Chairman.
You gotta be quick and
I
vigorous.
tried. I'll be more aggressive. Mr. Winnie, thank you. Do you think that this is a novel and brilliant way to come out for Wyoming and put in our statutes a definition of life? I think it's a pretty good idea. What do you think?
I don't know that I would have, Mr. Chairman, I don't know that I would have characterized myself as novel or creative. But I did a lot of writing in my time in command, and sometimes people didn't get what I wrote. And I had to go back and rewrite it, sometimes more than once. And like I said, I've watched healthcare professionals sit here and look you all in the eye and say, abortion is healthcare. Like I said, I got it on things like ectopic pregnancy, take that out of the picture. Those are sad, but they happen. So we get into a situation, and I believe this is the core of Senator Steinmetz's bill here, is, okay, let's make the words say what we, the people of Wyoming, want them to say. I hope that answers, Mr. Chairman, I hope that answers Senator Hutchings' question.
Thank you, sir.
Okay. Okay, yes, sir.
Good afternoon, Mr. Chairman. My name is Jesse Naiman. I'm a lawyer here in Cheyenne, Wyoming. I stand in full support of this bill. I think it's crucial we support the pro-life cause. And when this legislature passed the trigger bill, that was the bill that was supposed to say the policy preference of the state of Wyoming is no abortions. And it's unfortunate that this matter's been tied up in the courts. And I do think that this bill would be a good attempt, given the current state of things, to use the legislature's power under Article 1, Section 38 of the Constitution to define health care. So with that, I will stand for any questions. Thank you.
Question? Thank you very much, sir.
Mr. Bully, you're next.
Thank you, Mr. Chairman, committee members. Eric Bully with the Wyoming Hospital Association. We've been interested in this bill, and I think the amendments have cleared up some real confusion that we had. And we're not in support or against it. We're just looking for a little bit more clarity. I have a couple of maybe suggestions. I think section I and II helped a lot, but as we get into section III, I'm just wondering if it's a pretty long run-on sentence that still, I think, is a little bit ambivalent. I'm just wondering if maybe III should just say, no person shall perform an abortion except as provided in II, and take out all of that, take out that long sentence. I also am just curious, because it's something that we've talked about quite a bit when it comes to abortions. I don't see any reference to rape or incest in here, and I'm not sure if that's intentional or if it's just something that was overlooked. Those are my comments, and I'd stand for any questions.
Questions? Questions? Go ahead.
Mr. Bully, if things pass along, I'd be glad to work with you on some cleanup.
Great, thank you, Senator.
Anything else? Thank you. Former Representative Brecknell, am I right? Co-chair, I guess my speaker's on.
We can't hear you very well.
Yeah, you have to get close to the microphone in this setup here.
Chair, in my community, pregnant women
And do identify yourself for the record. just
Oh, I'm sorry, Mr. Chair.
formality.
Bob Breckton, Natrona County, in favor of Senate File 125. In my community, pregnant women are entering this unregulated so-called medical clinic. Babies are being torn apart without even a painkiller, with a cruelty not allowed for animals, up to 24 weeks within the warm safety of the mother's womb. This is not just religion, but science. That babies begin to experience pain as early as 8 weeks. Some gruesome reality of what happens to these babies is disguised by a veneer of false medical respectability. Unlike the respected and highly rated doctors in our community, the profiteers at this facility display no doctors' faces or ratings or credentials on their website. We've witnessed women coming out of this facility who are injured, put into personal staff cars, rushed to the hospital emergency room, really question what goes on. There's a plethora of carefully crafted euphemisms designed to confuse the people that come there. And we are the epicenter for the center of the nation of women coming there for abortion. Casper residents are a loving people. They're compassionate, pro-life. They never agreed to, or nor did they ever want to have the stigma of being a for-profit center of the destination for the center of the nation for abortion. This is a scandal against natural law, and these people voted against it. Thank you, Mr. Co-Chair.
Okay. Questions? Thank you very much. You're next, sir, and then you'll follow. Go ahead, sir.
All right. Thank you, Senator Scott. My name is Dr. Marcus Coolidge. I'm a family medicine resident from Casper, Wyoming, graduate of the WWAMI program in my third year of residency. I'm here to speak opposed to this bill. I understand the intent of it, and like the representative from the Hospital Association talked about, like, that's your intent, like, write that law. This law, I think, has a lot of unintentional consequences. I tried to kind of keep up with the amendments. I wasn't able to see them before, but just kind of writing things down as you kind of talked about that. Before the amendments, I had a lot of issues. I think there's been some cleaning up with that, but there's still a lot of things that are really worrisome to me as a future provider in this state. And so a couple of those things that kind of, sorry, I need to, even with the amendments, there's still things that I think that would not be defined under healthcare within this bill that I think are healthcare. And then the second part is I don't know in general that even within the health system, we don't have a great definition of healthcare, and it's because it's a constantly moving thing, and there's a lot of risk benefits that go into every medical decision we make. So putting something into statute that clearly defines what is healthcare and more importantly defines what isn't healthcare, I think is a very concerning to me. Just a couple examples in terms of things that I think would still be potentially banned under this. I saw the intentionally causes harm, and then medically necessary. There are things that we use all the time in medicine. We use things like immunosuppressants, which cause intentional harm. They suppress your immune system on purpose to provide medical care. You could argue whether or not they're medically necessary. Things like chemo is kind of in the same thing, and I assume that's part of the intent to protect some of those systems. But it's still, I think, so for me as a provider, it's very hard to figure out like what is going to be in this and what's not, and kind of wrapping through this. I think there's certain intent there, but it's hard to kind of figure out where that is, and that's makes it concerning for me. I'll stand for any questions.
Okay. Okay, seeing none, thank you very much, sir. Yes, ma'am, you're next. And people who are going to testify later, come up and fill the empty chairs.
Mr. Chairman, I'm Linda Burton. I'm with Wyoming Right to Choose. I didn't have a copy of the amendment, so I'm just going to make some brief comments on what I heard in my reading of the bill prior to that. One of the, part of the testimony was that the legislature can make definitions, which is certainly true under the Constitution. What it can't do is it can't direct the judiciary on how to interpret the law. That's not allowed under the Constitution. It's a separation of powers issue. I think this bill is not a healthcare law. I think it is a ban abortion law. That's one of the reasons that there are no exceptions for rape or incest, no exceptions for anything apparently other than the death of a pregnant woman, which can cover a lot of other things that can happen to women in pregnancy and in childbirth both. One of these statements that was made is that I have heard medical people testifying that abortions are healthcare. I think that maybe the previous gentleman just testified that abortions are healthcare. And I don't think it's necessary for the legislature to make those kinds of decisions and definitions because they are not medical personnel. We need to allow our physicians and our women to make those decisions on what is best for them in terms of their health and their family's health. I think that's all I have to say. If there's any questions, obviously, I oppose the bill. I think there's a lot of unintended consequences in this bill. And I think the other problem would be is including from the moment of conception. That might be a difficult situation when we're talking about determining something from the moment of conception. Any questions?
Senator Hutchins.
Thank you, Mr. Chairman. Nice to see you, Linda. Just quickly, I heard you say this bill is directed at stopping abortions. And I think you know that governments were instituted to preserve life, to protect it. So that's why we're here. That's the number one reason that I'm here, is to protect life. Would you agree?
Mr. Chairman, Senator Hutchins, health and welfare certainly is a legislative issue, and I agree with that. I don't believe that putting a fetus's health above a woman's health does that in any kind of rational or balanced way.
Okay.
Thank you.
Anybody else? Anybody else want to testify? Anybody else? Yes, sir.
Chairman Scott, Drake Hill. I'd like to address myself first to Linda's last comment, which was placing a fetus above the woman's rights. That is exactly why SF 125 is before you, is that that distinction needs to be drawn out. Up until now, the Teton County decision paid attention only to the rights of the mother. The mother's rights were, there were no other rights considered. Despite legislative findings, Senator Scott, to the contrary, the court ignored those. So what this bill does is it says that the unborn shall be equal in rights to the mother. And so now we go back to your point, Senator Scott, which is apparently something that comes from your church. And that is that a person is not a person until born. But we know, and this bill says, and the young doctor in training, I would hope, would agree with me, that something that has a heartbeat certainly must be a human being. Something that has respiratory function must be a human being. Left unaltered, that will become a child, it will become an adult. The fact is that we have a person, and at the moment of conception, the person has rights, and that's exactly what this bill seeks to establish. I will disagree also with Linda to the extent that she says, well, the legislature doesn't have the right to be entering into definitions or to be telling the judiciary what to do. You're not telling the judiciary what to do. You are simply performing your function. Your function is to make definitions. Article 1, Section 38 of the Constitution, which was the basis of the ruling from Teton County. You'll note in subsection C that the people of Wyoming, whom we certainly can't ignore here, can we? The people of Wyoming said that the legislature may make definitions. That's subsection C. And of course, that is what you are doing. That is your legislative directive to bring meaning to the section and to place limitations upon the section. And the people of Wyoming trusted you to do this. The young doctor said that it's a difficult section to understand, feigning confusion. There's no confusion here. This bill is a tightly crafted bill addressed to a specific topic, and it is intended to make those definitions and to make them very clear so that when, I'm sure when this comes back before court, the court has clear direction. And that doesn't have to work on ambiguity or lack of clarity. The court gets to know from the legislature what needs to happen here, which is the legislature's prerogative. I'll stand for any questions.
Questions? Senator Hutchins.
Thank you, Mr. Chairman. Mr. Drake, just wondering, going through the bill, are there any areas that you feel are not needed, could be made stronger? Just your opinion, sir?
Chairman Scott, Senator Hutchins. The fact is, Senator Hutchins, this bill was crafted with a tremendous amount of legal assistance. This bill was the product of very careful research, very careful drafting. I think it stands as it needs to stand.
Thank you, sir.
Any further questions? Okay, thank you very much. Anybody else? Anybody else? Yes, sir.
Mr. Chairman, Nathan Winters, President of the Wyoming Family Alliance. I'll be very quick. I just want to speak today and address the assertion that was brought forward that this is not the appropriate place to address the issue of abortion, when this is the, in rather that a doctor and a mother are the only two that really weigh into that. It is the role of civil government to protect life, and it is this branch that crafts the law. I would assert it clearly is not a judge functioning as a single person legislature who should be defining what laws are. That is an overreach of that position. And so legislation like this is important to help signal from from this body, what the law should be, and it is defined here. Thank you.
Questions?
No, sir.
Okay, thank you very much. Sure. Anybody else? Anybody else? Is there anybody online? How many?
Two, Mr. Vice Chairman.
Okay, get the first one.
Mr. Chairman, can you hear me?
We can identify yourself and proceed.
Mr. Chairman, my name is Emma Laurent. I represent Wyoming United for Freedom. I am testifying from Sheridan today against Senate File 125. I would like to read to you a snippet from the article published in The Guardian 3 days ago about this bill. When asked if any doctors or medical professionals were consulted in the authoring of the bill, Senator Steinmetz said that she received the bill from an attorney and was not sure who the attorney sourced input from. She said that the bill sponsors were aware of concerns about chemotherapy and other procedures and that they would sort it out if the bill moved forward. I find it asinine and irresponsible that a member of our government would bring a bill forward that would affect so many Wyomingites without doing her due diligence to understand the impact of this bill and to say that on record. For this reason alone, this bill should not move forward. A new public opinion poll released last week by Perry Undem found nationwide that 71% of all voters, Republican, Democrat, and Independents alike, agree that abortion should remain a decision between women and their doctors, regardless of their personal beliefs on the subject. This new definition this committee is considering has no medical basis. It is merely another tactic of a minority faction to exert government overreach and place government control over women. I stand for any questions.
Question? No. Okay, seeing none, thank you. Who's next? Met them.
Mr. Chairman, can you see me and hear me?
Yes, we can hear you. Identify yourself and proceed.
Hi, my name is Alexandra Etzinger, and I am testifying before you today in support of SF0125, a bill that seeks to recognize and protect the inherent human rights of the preborn of Wyoming. I believe that every human being, whether born or unborn, has inherent dignity and right to life based on constitutional grounds and that of I urge you to support this bill to ensure that our state upholds its moral and legal responsibility to protect the most vulnerable among us. From the moment of conception, a unique, genetically distinct person has been created. This new life with its own DNA, although dependent on its mother's body for a time, it is a separate living human being with the potential for growth, development, and eventually becoming a full-form member of society. The question is not whether personhood begins at a particular point during pregnancy, because personhood is not based on arbitrary milestones, but on the inherent nature of being human. But whether we will acknowledge that every human being, how small, deserves to be recognized and protected as a person. Governments exist to protect the rights of their citizen, and it is a primary duty of the state to ensure that those who cannot speak for themselves are afforded the full protection of law. Just as we protect the elderly, the disabled, and other vulnerable individuals in our society, we must also protect the unborn, those who have no voice, no vote, and no means of defending their own right to life. To deny the protection to the unborn is to abdicate our responsibility to protect human life at all stages. Every person, from conception to natural death, is entitled the most basic human right of all, the right to life. This right is fundamental and must not be withheld based on arbitrary distinctions of size, conception, location, or the circumstances in which it was conceived, development, or dependency. As we affirm in our Declaration of Independence, every human being is endowed with certain unalienable rights. Among these, the right to life. By recognizing personhood at conception, we reaffirm our nation's commitment to the dignity and the rights of all human beings without exception. The 14th Amendment of the United States Constitution guarantees that no person shall be deprived of life, liberty, or property without due process of law. If we recognize the unborn as persons, we must extend this fundamental protection to them. Other states and even nations around the world have recognized personhood at conception as a way to uphold the rights of the unborn, and I urge Wyoming to join this movement toward justice and equality. In conclusion, I urge the committee to pass SF 0125, which would affirm that personhood begins at conception and extend the protection of our laws to the unborn. This is not just a legal issue. This is a moral imperative. We must act to protect those who cannot protect themselves. I trust that you will stand for life, stand for justice, and stand for the unborn. Thank you for your time and your consideration. And I still have questions.
Any questions? No? Okay, thank you very much. That concludes testimony. I didn't see any other further here. Back on closed public testimony, back on the bill. Do I hear a motion? Motion is due pass. Senator Steinmetz, did you have an amendment? You have an amendment. You can move it.
Mr. Chairman, yes, I'd move the second amendment that I gave you, the one with written out. It has the definitions written out, not simply referred to in statute.
Okay. Do you have those properly? You know which one she's talking about?
Mr. Vice Chairman, is it this one?
That's correct.
Okay. Been moved. Comments?
Mr. Chairman, I think this is a critical component of the bill. As we talked earlier, there were some things during drafting that needed to be tightened up, and this is a necessary component for this bill to be successful in accomplishing its purposes.
Okay. I will comment. I think that is accurate. The bill as originally drafted, I could not understand. And I can't understand this one. I don't agree with it, but I can understand it. So I think the amendment is essential. Any further discussion?
I think, Mr. Chair, if you don't mind, it's like when you spend a little time tracking all the information and reading it, and of course, you know, it seems like the bringer of the bill spent a lot of time trying to work with everybody to make this a good bill. So I think once all the amendments are tracked in, and it would be nice to get that for the people on the floor to go ahead and let them see the bill in its entirety instead of all the different areas here. That's the way I'd love to see it go to the floor, and then we can work on it from there.
I would send it to the floor as a substitute bill if we had more time, but we don't, and I think people can understand the amendment.
Mr. Chairman, I'll get them either a typed out one or a tracked in one. I'll make sure that it's understandable.
Okay, thank you. Okay, questions on the amendment? All those in favor say aye. Aye. Opposed? That carried. Any further amendments? Further comment on the bill? I will raise one other thing. You know where I stand on these long-term. This one scares me especially because normally when we define something, it's defined for this section or this article. This one purports to define healthcare for the purposes of definition, interpretation under Wyoming statute and all statutes of this state. That lays us open to unintended consequences elsewhere, and I think that is, this concern was raised by some of the testimony, and I think that's a valid concern with the bill with this amendment in it. So I think that's something you need to consider before we get to the floor, because this could have, because most medical care involves a certain degree of risk, and sometimes when you have a very serious medical condition, the risks are very high. So I think you need to be extra careful about real unintended consequences in this bill, and I think that will be a legitimate question upstairs. Senator Hutchins.
Thank you, Mr. Chairman. Do you think, looking at page 2 between lines 12 and 13, does that help at all alleviate some of your concerns with the information that was added therein? Does that help at all? I know it's kind of a quick,
Page 2, lines 12 and 13.
yeah,
Yeah, it's this section.
necessary for the treatment of
Yeah,
an illness or
this is one of the
injury.
places I have trouble with the bill.
That's where you have trouble.
Okay.
Okay. Okay,
All right.
any further discussion? Call the roll, please.
This is a roll call vote for Senate File 125 as amended. Senator Crum,
He's excused, he must be going through the third degree on his bill
Yeah.
somewhere.
Senator Hutchings,
Aye.
Senator Scott,
No.
Senator Steinmetz,
Aye.
and Chairman Barlow has left an absentee vote of aye.
Okay, so there's 3 ayes on it.
3 ayes, 1 no, and 1 excused.
Yeah, hold it open briefly to see if you can get a vote from Senator Crum.
All right.
Yeah, and,
Thank you, Senator Scott.
okay, if you can't get a vote from Senator Crum by the end of the day, get me a draft report to sign.
Let me get it for you.
Or maybe, Charlie, do you have your extra?